Good morning, students. As promised, I'm putting together this little video here for the cases dealing with limiting the powers of each of the three branches of government. So there are three cases you need to know to be successful on this unit test. So case number one, Marbury versus Madison. Marbury versus Madison deals with, of course, judicial review. Judicial review is the power of the Supreme Court to review a law or review an action taken by a member of the government or a government agency, to review it and to ensure that it is in keeping with the spirit and the letter of the Constitution. In other words, they can look at a law, look at an action, and decide whether or not it is a constitutional action or law. If it is, so be it. If not, the Supreme Court has the power to throw it out. Okay, so Marbury versus Madison, judicial review. The second case we looked at is McCullough versus Maryland. Now, McCullough versus Maryland, this had to do with the Congress creating a bank in the state of Maryland. The purpose of this bank was to accumulate all of the taxes for that state, and they built this bank. Now, the state of Maryland attempted to put a tax on the bank of the national government, arguing that the national government, of course, did not have any power to create a bank because it did not say so in the Constitution itself. So the question is, can Congress do things that are not written in the Constitution? And the answer is yes. Congress is able to do things that are necessary and proper to carrying out its other powers. So if Congress feels that they need to create a bank in order to hold all of the money that they're collecting in taxes, which they are able to do, then they're able to do so. In class, we called this ability to take the powers that are in the Constitution and expand them, we call this the elastic clause, which means the ability for Congress to be able to stretch their power in order to do the things that they need to do. Okay, so in essence, McCullough versus Maryland is the elastic clause. It's elastic, boogie woogie woogie. All right, so the third case that we went over in class this unit is U.S. versus Nixon. This is a case involving President Richard Nixon. He had recorded a bunch of conversations that may or may not have included proof that he had been knowledgeable or even perhaps even guilty of ordering the break-in into the Watergate Hotel in the Democratic National Office. So Congress wanted to listen to these tapes to see if the president knew or planned it. Richard Nixon said no, he did not have to share these tapes, these recorded conversations, because he had something called executive privilege, which again is a power not found directly in the Constitution. So the question before the Supreme Court was really two things. A, is there such a thing as executive privilege? And B, if there is, can Richard Nixon use that power in this case to hide and keep these recordings of his conversations? So to the first question, is there such a thing as executive privilege? The Supreme Court said yes. The Supreme Court said that the president does have the ability, as the head of the executive branch, to keep certain things private, to, in essence, keep certain secrets. But the limitation that they put is that these secrets must and have to do with national security or war purposes. So I could not just roll up to the president and say, hey, I write for the Mr. Kiernan Daily News website, and I want to be able to tell all of my readers where we're hiding the nuclear weapons. Or, hey, I want to know the passcode to your phone, and I want to put it on my website because you're the president and I can ask you questions and you have to tell me. Obviously, these things would not be good. So the president does have the ability to keep some things secret as long as those things have to do with national security. So there is such a thing as executive privilege. It does have to do with keeping secrets for national security, which means the second question is, can Richard Nixon use that power to hold these recordings in? And the answer to that, Supreme Court said, was no. That because this issue of whether or not Nixon recorded conversations about him planning a break-in of an office facility of a private citizen organization, that has nothing to do with war, it has nothing to do with national security. And because of that, the rule of law says that if the president is doing something illegal, or just like anybody else, there needs to be accountability for that. So the Supreme Court ordered Nixon to release these tapes. Shortly thereafter, Nixon, fearing that he was about to be impeached, because he was, resigned and stepped down as president. So U.S. versus Nixon is all about executive privilege, saying the president does have this power of executive privilege, but limiting it to only in issues of national security. So to review, Marbury versus Madison, judicial review. McCullough versus Maryland, the elastic clause. It's elastic, boogie woogie woogie. Third case is U.S. versus Nixon, which says that the president does have the power of executive privilege, but only in cases dealing with war and national security. Okay, so those are the three cases that you need to know for this test. Good luck studying.